right, so this is the nuts and bolts panel, and basically what we're going to be talking about is the mechanics of how you build your practice when you're starting out on your own. And I just want to thank the City Bar first, because you always thank the host. And if those of you who aren't members of the City Bar, you should consider joining, because I just want to say, like, what it's done for me is that I'm standing right here in a spot that I know that Ruth Bader Ginsburg has stood in before. And I don't think that would have happened to me 3 years out of my admission to practice if I wasn't a City Bar member. So, all right. So I'm going to start introducing the members of our panel. First, we have Lori Ann Fox. And Lori Ann is a government relations and regional attorney for CT Corporation, a Wolters Kluwer business. Lori Ann focuses on business entity law and related issues. Okay, and then to her left we have, I don't want to step out of my mic. To her left we have Vaughn J. Buffalo. Vaughn is the principal attorney at Buffalo and Associates LLC, a boutique law firm specializing in mergers and acquisitions, as well as general corporate legal advice. And then all the way over here to my right we have Matt Foreman. Matt Foreman's firm is the law offices of Matthew E. Foreman, PC, a boutique law firm that focuses on advertising domestic and foreign businesses, advising domestic and foreign businesses and individuals in a variety of tax issues related to business formation and operation, raising capital via equity and debt, and acquisitions and sales of businesses. And then to my immediate right, we have John Clapp. John Clapp is a co-founder and partner of Clapp, Kelner, PLLC. He is a seasoned corporate and securities attorney with almost 30 years of broad-ranging experience in cross-border transactional matters. He has an extensive track record leading international mergers and acquisitions, restructuring, debt and equity capital markets transactions, and securities and compliance matters. All right, so welcome to our panel. And one thing you might notice about the panel is I was introducing them as each of them, I believe each of them has a different entity from the other one. So that's going to launch us off into our first topic here. We're going to be talking about the choice of entity for your law firm when you're starting out. So let's get started with Lori Ann. This is something that you do. You advise people about choice of entities. Why don't you start us off with that?
Thank you, Ann, and thank you all for being here this morning. Yes, I was given the exciting topic of choice of entity for starting a law firm. I know you guys are going to snooze through this part because you didn't get enough sugar and caffeine. That's okay. Eventually you'll perk back up. There are a couple of interesting things, though, that are related that are probably, I think issues that we don't always consider, and they apply across the board, whether you're talking about starting a law firm or you're doing something for a client. Part of my experience comes from sitting on legislative drafting committees. So I've seen a lot of issues arise over the years, and, as they come up, of course, there are always lawyers on the committees, and we start, discussing these and getting into them. So I was asked to focus on today were corporations and LLCs. And there are four main issues when you get to corps and LLCs, and you're talking about liability, control, transferability, and taxation. Now, I'm going to hold taxation to the very end because Matt has a few words that he is going to add as well on taxation, I know. So where I'm going to start, though, is on the corporation and the LLC. And they also asked you for the professional corp and the professional LLC because, of course, if you're starting a law firm, that is an issue for us. Now, presumably, you're going to be doing this in New York as opposed to in another state, but it kind of depends on what your goals are, because I also know you have a tri-state area here, so it would be possible for you to have your firm in multiple jurisdictions. How many of you think you might be doing that or already are doing that? Okay, so it does become an issue. So you run into this whole question of, okay, then how do I choose the state as well? What becomes most advantageous? So just as kind of like little teasers out there, I will tell you that I was looking through New York, since I'm not barred here. I'm barred in Texas, Georgia, and Oklahoma, so I have to go in and check, and I checked with one of my colleagues who is barred here. And one of the things that I found is that there's actually a restriction on using the word lawyer when you are registering an entity, but not law and not law firm. So you want to take that into consideration. Now, of course, I didn't have any issues when I was setting mine up, and I've had a PC and a PLLC in my history down in Texas, and that was never an issue for me because we don't have those issues, and there was always law office of or law firm, so it was pretty simple. So we'll talk first about the most important thing in my world, which is liability. And you're going to get liability protection on both so long as you maintain accurate books and records. So whatever the entity is responsible for, it's still responsible for it. Now, that does not keep you, of course, from malpractice issues, so make sure you have a good insurance provider on that. But at least if you have other potential liability issues for the entity itself, you should be protected so long as you're maintaining your books and records. You do want to keep in mind that with a single member LLC, it can get a little more questionable than with a single shareholder on a corporation. So that's kind of something to just think about. When you're talking about control, now here's my other question. How many of you are actually going to be solos? Okay, so most of you, and how many of you are going to, just so I get a raise of hands so I can see it, it's easier for me to visualize. How many of you actually have a partner or two, or you're doing this with others? Okay, so not quite as many. So here's one of the things that can arise when you get into having others involved. For all of the solos who are just you, that's fantastic. If you ever think about taking somebody on, consider the following issue. When we're talking about control, we're talking about who's making the decisions. On a corporation, of course, your directors are making the decisions and your officers are carrying them out. Now, do you have a statutory closed corporation in the state of New York? Anybody? Not all states have it. Some states do. With a statutory closed corporation, if you are going to be a solo, you may look into the state that you're going to be practicing in or the state where you're going to register and then transfer over. See if they have a statutory closed corporation, because what it does is it allows you to dispense with the board, and the shareholders just make all the decisions and move straight forward. So you do have to be a little bit more careful. It's usually for a family-owned business. On the LLC, of course, the default is always the members or the owners, but of course you can make it manager managed as well, and with an LLC you can have an entity even serve as your manager. You do have to watch, though, when you're talking about a law firm, because many states do have restrictions on non-lawyers being an owner or part of the practice itself. Transferability is probably one of the most interesting things when you get down to these entities, because there you're talking about being able to transfer the ownership rights. Now, I'm going to ask a silly, easy question that hopefully somebody can help me out with just to make sure you guys are still awake. And that is this, and I'll take my panelists as well. If I ask you, what are the two things you get with owning a share of stock, any share of stock, it could be IBM, Apple, Google, whoever. What do you get? What are the two things you get to do with it?
Voting rights.
Vote
Vote?
and residual profits.
Money. You get money and you get to vote. So when you have a corporation, you do have free transferability, unless, of course, you have a shareholders agreement that would limit such. With an LLC, you run into more challenges, especially depending on the state that you're in. With an LLC, traditionally, it did not have free transferability because we wanted to get a default taxation position, and therefore you couldn't have free transferability. That has changed over the last 40 years now, since the first one was adopted in 1977 in Wyoming. Now, move forward, and here's what I'm going to tell you is where we run into the issue with ownership and that transferability concept. If you end up with having partners, not that they're really partners, but you know what I mean. You have others in your practice that you are sharing with. So if you end up in that situation, you now have to start thinking about how does one or the other of you or multiples get in and out? And are there any restrictions? And can you freely transfer? And what do you need to put in your operating agreement? But here's the more important issue. How many of you are in a state with community property laws? Nobody?
That's atypical for this area of the country.
Okay. But here's the issue. What if you took me on? I live in Texas. I am in a community property state. And I will tell you right now that if it's an LLC, my interest, my ownership is fully owned by my spouse. So any type of entity, you have to start worrying about those issues. So even if here you don't have that particular problem arise, you do still have the issue if you're taking on a partner or you're taking on someone else that you're doing business with, because let's face it, what if you wanted to cover both coasts, New York and California? Now, I am...
As a community
I know
property
California
jurisdiction,
it's also has great paternity laws as well. But anyway, so I am pretty much over my 7 minutes. So the last thing I'm going to talk about is taxation, and that is this. Your default for a corporation is subchapter C of the Internal Revenue Code. You have the option to elect sub S, but you have restrictions on that. With an LLC, if you're solo owned, single member LLC, your default is sole proprietorship, which is pass-through taxation. If you have more than one member, your default is subchapter K, which is the partnership code for the Internal Revenue Service. Then you have the option to elect to be a sub S or a sub C. And I know Matt has New York tax issues that he wanted to highlight.
Yes, and general tax issues. And before we get started, does everyone understand what Lori means when she says pass-through taxation? Is there anyone who does not understand what that means? Okay, why don't we have Matt explain that to us first, because we can take a really quick question, just one. Why don't we pass
I'm
that
going to
to
slightly
Matt?
interrupt
Yeah,
you.
let's go ahead.
I'm a firm believer that the current proposal will be modified in substantial ways before it's really voted on.
And Matt, can you tell us a little bit about that proposal, just to fill in everyone in?
Yeah, I'm not going to get into the specifics, but there's one proposal, the House Republicans are currently marking it up, and I think that based on who has contributed to what campaigns, things will change pretty substantially. And I think that the Senate Republicans will act very differently because they tend to have different things and they're in different places. So I'm not, I've read through it. I read the 89-page one pretty thoroughly. The actual thing is 400-something pages, which I've gone through, but it's going to get changed in such a substantial way, I wouldn't worry. Plus, a lot of the pass-through rules with the lower taxation don't apply to true service partnerships. And law as a service would be a service partnership. I'm not sure how it wouldn't be, but
Okay,
so
so
to get
can we move
back
on to the general
and
tax rules that
but
you wanted?
the point is, a pass-through is basically the entity doesn't get taxed. That is entirely untrue at the city level. New York City, because of what New York City is and the fact that no one leaves New York City for tax reasons, at least business tax reasons, there are two taxes that really don't exist elsewhere in the United States. So the first one's called the unincorporated business tax. It applies to anything that's taxed as a partnership. So LLPs, LLCs, PLLCs, LPs, all sort of that, and also sole proprietors. So if you don't incorporate, you have this. And it 0% tax up to $85,000. It phases up to 4% above 135%. It's a gradual slide up. And so that can be a tax that, especially if you have someone who's handling your taxes who's not in New York City or around New York City, will probably miss. Because it's unique and it's very specific and it's on New York City source income. So if you have some source income that's from Rochester and you have some from New York City, they're actually taxed differently. The other one is New York City doesn't recognize S corporations for tax purposes. So there is a 6.5% flat tax on it. People always ask me, well, why would anyone use an S corporation? And the answer is corporations and S corporations, you're allowed to deduct the reasonable wages paid to shareholders. So if you're a solo or small firm attorney, and, for example, I know VAUGHN is a PLLC, but he actually made the S election. I'm an S corporation as well. And what it allows you to do is you can deduct part of the wages paid to yourself. So there's different taxes based on a dividend versus a wage. So that's something you want to consider. And I'll be a little brief and hand it back to Ann.
Yeah, and before we leave the tax issue, I remember in our discussions leading up to forming this panel, we discussed that maybe some people have started practicing like I have without incorporating at all. And I posed the question to Lori, can't you just change your form of entity along the way? And I do remember Matt brought up that there might be some tax consequences. So if we can have a quick discussion about for some of us, it's too late. We already started practicing and we haven't formed something. What do people like us need to think about?
I will tell you that you can always convert the way that you're doing business. What you have to start thinking about are what are the costs for it. Because depending on what you're doing, especially Vaughn is an M&A lawyer, when you start getting into conversions particularly, now you don't have that issue with the sole proprietorship since the most you would ever have on file would probably be a voluntary assumed name with the locality. But if you're actually registered with the state as one, you can always convert to another, but you can trigger a tax consequence with that. Whereas with a merger, if, for example, you had two solo corporations, two solo-owned corporations that decided they were going to merge together and create another firm, because that is a possibility as well, then you can start looking at ways that you can reorg with that merger without triggering the tax.
Okay.
So there are always those types of issues. The one thing, if you don't mind if I go back, that I will say about New York to keep in mind regarding your corps versus your LLCs is, of course, the filing fees with the state aren't so bad, but the publication fee that you all have had for 11 years now and still counting and still grumbling
Yeah.
and unhappy about can get quite expensive for your LLC, and that's required within 120 days of your filing. So.
Okay. And Matt, did you have anything to say about those tax consequences of changing the form of your entity midstream?
Talk to your tax advisor before changing entity in any consequence, any situation. It depends on what you're doing and how you're doing it, and it can be very form-driven. So talk to someone about your specifics before you do it. That's my entire advice for that.
It's so complicated, we basically have to say, you have to give the specifics of your case to someone who knows what's going on and take advice.
It's often no problem, but talk to someone who knows what they're doing, because it's just, if you mess up, it can be very bad.
Okay, thank you very much. All right, so we are going to move on. Hopefully we'll have time for more questions about these topics later on. But we're going to be moving on to Matt, who's going to be talking about IT issues. He's going to be talking about hardware and software. And if you would like to get started, Matt, thank you.
Yeah, so a big part of starting a firm is you need some sort of technology. And I always say that there's three big things you really need in terms of hardware. The first one, obviously, is a computer. At this point, pretty much everything, I actually think you could probably get by on an iPad at this point, with how most lawyers function and all the applications available to it. So really, whatever you feel comfortable. Get a printer. I have a wireless multifunction. Having a scanner is very, very, very helpful. And it also allows you, especially with the electronic fax services that exist, to be able to fax without having to go somewhere or have a fax machine, which I assume still exists. The one piece of hardware that I think a lot of attorneys miss is one that's a little less intuitive, but it's a shredder. A lot of attorneys say, "Oh, I'll just rip it. That's no problem." And if you ever put together a puzzle, you can probably put together a piece of paper with someone's social security number on it. So having a good cross-cut and vertical cut shredder can really be helpful. A lot of office spaces also have shredding services. They'll have a secure bin, someone comes, they shred it, it's gone. It's something that I really recommend investing. If you're someone, I work from home a fair amount, I have a shredder at home, and it's worth investing a couple $100s to have it, to not worry about it, because it's expensive, and if something happens, it can get really, really expensive, and companies, big law firms have this issue, and soft law firms are a very soft target in that one. In terms of software, the first thing to consider is productivity software. Pretty much all of us at this point use Microsoft Word. There's also the G Suite has their applications that do similar things. There's Office, which is a physical product. You can have it once and then it doesn't really update. There's also Office 365, which is subscription-based. You pay a certain amount a month. And what it means is you have the most up-to-date Office at all times, and you pay, I don't know the exact amounts, but those are the two options. I can't advise what's best for you. It's how you want to do it if you just want to update every few years. Antivirus, anti-spyware have it. There are people who are like, oh, I have a Mac, it's not a big deal. I promise you that those law firms that lost all that data a couple days ago in the Paradise Papers were probably using Macs as well. No computer is impervious to anything. The only way to avoid viruses and everything entirely is to never go on the internet. So good luck. Anyone who create a website, web hosting, things like that, they can help you get set up, talk to it, and see what they say. A big part of it is data storage and backup, which I believe is VAUGHN.
Did you want to interject something about data storage? And also, as we're tossing it over to Vaughn, too, one thing we haven't mentioned yet is cloud computing, which is kind of the way data storage is going. And this also implicates security issues and our professional responsibility. So if we can, discuss a little bit about what your storage solutions are and what you recommend.
Well, generally, as far as what I want to talk about mainly is, how you transfer from where you're working now to, having your small law firm. And there's a lot of considerations that people, if you're working at a law firm or a big law firm, you may be trained at a big law firm or started at a big law firm, you don't actually, work on, these kind of back office things, which are very, very important. As far as storage goes, we had one speaker, and I think he hit the nail on the head, to have one database, right? Now you can have cloud storage, and there are clients of mine that require me to upload and use Dropbox. Dropbox is in the scale of security, Dropbox is pretty much on the lower end. But as far as the usability, it's, a very easy, solution to have. Maybe I'm a little bit of a Luddite in that, I have all of my files on my server, and I back that up physically to a drive periodically that I bring elsewhere, so that if my office burns up in a fire, that I will have my files somewhere else. So there are also, some great other solutions where your files could be will be stored on a server which is secure. Like I know Amazon has a service. I know Carbonite and these kind of things.
And as regards the professional responsibility and the security with Dropbox, one thing to note is per the professional responsibility rules, the confidentiality belongs to the client. So the client can waive that confidentiality. If they insist on using Dropbox, you are permitted to use Dropbox, but it is a good idea that if you have knowledge that something is less secure than something else, that you make sure that they're making informed consent about that. And also Dropbox isn't open to the world. It is a secure manner of transferring the documents to the client, but you always want to make sure that the client is making informed consent about how secure their documents are.
I want to make one point, and that is, and my general point is this. When you're working in a law firm, if you think about your small law firm, there's inflow, there is managing the work, and then there's payables. So receivables, work, and payables. And receivables, you've got to do marketing with respect to that. So I put it on a chart, right? So I have inflow, and I write down bullet points of all the things that are related to inflow: marketing, selling, time management. There's the mechanics of doing the legal work. I have bullet points on that: organization, storage, precedence, time, employees, that kind of thing. And then outflow: payables, vendors, space, insurance, advisors. These are things that no one thinks about if you're working at a big law firm. And the moment you step out and you hang your own shingle, these are the things, these bullet points are things that you are going to have to deal with, and you're going to have to figure out. And final piece of advice I'll give is that every January I take a 1-week vacation for myself. No wife, no kids, no friends. Well, I go and hang out with my I go hang out at his house. But I go to the coffee shop every day, and all I do is think about my business and what I can do to improve it for 7 days straight. Then I come home.
Okay, and thank you, Vaughn. And moving on from what Vaughn was saying, when you do an intake, we've got John here to speak about template documents that you want to use, including your retainer agreement, which is one of the most important documents that you're going to have. And again, if you've come from big law, you may have never seen a retainer agreement. You may not really know what drives one. So, John, if you want to get started talking about that.
Thank you, and good morning. I'm going to talk about two requirements that have been promulgated by our supervisory body, the New York court system, newyorkcourts.gov. The first one is the requirement that every attorney with an office in the state of New York post a client bill of rights. It's right there on the website, 10 paragraphs. You don't have to worry about the wording, but it needs to be displayed in your office. So I recommend you print it out, put it in a plastic sleeve, or maybe even better, laminate it and have that in your office. So that's a compliance check on that. And these address all the things that, of course, you're going to do anyway. You're going to be courteous to your clients. You're going to provide competent service. You're going to explain your fees, so on and so forth. It's all in there. That's one of the required documents. The other one I want to spend a couple of minutes talking about is your firm's engagement letter. Again, there is a requirement put out by the appellate divisions for each of the districts in which we practice in the state that you provide the client with an engagement letter. The one relevant exception is that any individual matter where you do not expect to charge in excess of $3,000, you're not required to have an engagement letter, but anyone who aspires to attract and have clients pay them more than $3,000, you might want to spend a bit of time while you're getting your practice together in drafting your engagement letter. Now, the required content, it's not very much. You have to disclose the scope of your services. You have to explain how fees and disbursements will be charged for, and you have to alert the client to the right to arbitrate. You can set that out in one page. So there are plenty of law firms that just have that one page setting up. There's very simple, we'll charge by the hour, we'll pass the disbursement through to you at cost, scope of services is this, and you can arbitrate. This is, after your marketing, this is the first point of formal contact with your client. So it's worth spending a bit of time thinking not just about what is this covering and, am I getting it right, but set the tone for your clients. I once attended a panel where we all brought along our form of engagement letter and we did a compare and contrast, and they ranged from the one page up to somebody who brought along something that's 15 or 20 pages long in legalese. The zinger at the end was that the client acknowledged they had retained independent counsel to advise them of their rights under this engagement letter. So you can imagine if everyone had that, that would be full employment going around the block for everyone. I think, the happy medium is a friendly, plain English document that's maybe three to 4 pages long, includes that required content, and some other recommended content to think about is, naming who the responsible attorney is if you're in partnership, but even if you're a solo, putting in the contact details for your backup attorney that your insurance provider will probably require you to have. So it's right there. So if the worst should happen, your client can go to the engagement letter and they'll know who to call. Talk a bit about conflicts of interest. If you have identified one, that's where you address the waiver. And you're not ethically allowed to get an advance waiver, but you can at least point that out that, you would ask the client to consider that if it were ever to arise. You can talk a bit about the limits on the attorney-client privilege, fraudulent matters, or, if you're subject to a court order, there may be limits to the attorney-client privilege. Talk about the circumstances in which you might terminate. Talk about your document retention policy, and circling back to a point we were just talking about, this whole issue of electronic communication. If you have the client consent to receiving documents by email, having their documents stored in the cloud, that goes a long way to addressing some of the issues that we were surfacing a couple of minutes ago. And maybe you might want to include in there a consent to including the client's name in your marketing materials. So those are some of the highlights of what you might want to put in the engagement letter. Just a couple of other documents you might want to have ready. One is the what I might call the non-engagement letter. You have a prospective client who comes into the office and talks about possibly retaining you, and then for whatever reason you or the client decides that you're not going to go forward with the representation, it's a good idea to have that in writing. And the points you need to hit are: one, alert the client to the fact there may be impending deadlines. Don't need to be specific, but there could be statutes of limitations, filing deadlines coming up, and that they should seek competent counsel. That's the main situation you want for that. It also can come up in situations where you've got a lot of potential clients around a deal, and you want to make it very clear that you're only representing one client, and you might want to send out to others something, a similar sort of letter saying, I am not your lawyer. So to have that wording ready, not very complicated, but worth working on ahead of time. And the very last one is the what I would call the disengagement letter, where you want to terminate the representation. That may be for non-payment, or it may be where you have an ethical issue that you avoid a conflict if the representation has terminated. So those are just a few documents that you could spend a bit of time working on, because you're going to need them when you're in the thick of your practice.
And one professional rule to keep in mind as regards the non-engagement letters and termination of engagement is that the attorney-client relationship has been deemed to start when the client believes it has started. So if you're not being explicit that you're not taking this person as a client, or you no longer consider them a client, you may be bound by professional responsibility to be looking after that client's interests. And that's why that's so important.
I want to add one other thing as well, is that in the in consent for a conflict or a waiver of a conflict in New York, it's informed consent, and so and I think that New York kind of views informed fairly broadly. So if you get like a one-line email from a client that says, I hereby consent to the conflict, right? I'm not sure if that works. I think you want to be a little bit more careful when you do get a waiver of any kind of conflict.
Yeah, you set it out in quite a bit of detail right there in your engagement letter. This is to inform you that we represent XYZ Corporation, that there's a potential conflict here on matters unrelated to this issue, and to set out some of the consequences for the client. So the more explicit you are, but that's probably not, you can't ever have template language for that kind of thing. It's when it arises, you need to spend a bit of time figuring it out and putting it down in writing.
And then there are times when the conflict of interest is so great that even if both parties are willing to waive the conflict of interest, and I have this come up sometimes in my upstate practice because I practice in some very rural counties where there are not a lot of lawyers. And sometimes, this may not come up as much in the city, but sometimes there's the perception that if one lawyer is drafting everything, both parties are protected. And for instance, I recently had someone ask me to represent both sides of a business transfer, and I said, I'm just not willing to do that, because when you're transferring a business, you really have to zealously represent one side or the other. You can't just, it's different if it's a real estate transaction. But if you're talking about a business, one person's getting out with what they want to get out, one person's entering with what they want to enter with, I said absolutely not. So when it comes to the conflict of interest, sometimes our professional responsibility is to walk away from that, no matter how much people are saying, but you're the only attorney we can find. Give them lawyer referral service numbers, find them another attorney, but just represent one side and have the other side be pro se, but don't get involved if the conflict's going to be too great.
Yeah, so in the engagement letter, you are very explicit as to who the client is, and the other party, you send them, I am not your lawyer letter. Exactly,
and make that very explicit. And also, a lot of times when I've been asked to do that upstate, and again, it has never come up in the city, I also explicitly recommend that they do get a lawyer. I say, this is my recommendation that you do get a lawyer, and the recommendation of my client. So it doesn't look like we're trying to have some kind of undue influence on them. Okay, so moving on to our next topic, I'm just going to throw a question out here, and I guess we'll start on this side. We'll start with VAUGHN. Good,
because I haven't had very much time to talk.
I know, I'm sorry, and we were limited in time a little because we got started late. So, VAUGHN, was there one thing that blindsided you after you went out on your own?
Oh, yeah. So that's the question I get. I get what blindsided me. I think the biggest thing that blindsided me was my being able to understand my fear that changed my ability to practice well. What I mean by that is you need to bill your clients fast and furiously, right? And what I would do when I first got started is I didn't want to send out the bill. I was nervous about that, or, are they going to really pay me, or I haven't really attained the milestone yet, or these kind of things. That was the thing that was, when I first started out, was the hardest thing to do, because, I was taught how to do the law. I was taught how to write a contract, but I wasn't taught how to sell somebody, look them in the eye, tell them you pay me or I can't do your work. That is one of the things. And then, I've been in business for 14 years now, so I've had many of situations where clients walk in and would say, well, I can't pay your retainer. And I can't do your work. Or they would say, well, I paid you this little retainer and I want you to finish it without me filling up the retainer. And I'll say, well, you paid this amount of money and I provided this amount of work, and if you want a half-made or half-done contract, I'll be happy to give it to you.
So it's kind of the wearing of many hats that kind of took you by surprise. You're not just a lawyer, you're a small business owner, and you have to kind of take off the lawyer hat for a minute.
Well, there's you're a business person, but I got to call it for what it is. It's the fear of not being, that you can't do this or something like that. That will be a hamstring around you.
Mm-hmm. And Lorianne, you've been a solo before, have you not?
Yeah, I have.
And was there anything that blindsided you after you went into your solo firm?
Well, I was really young when I did it the first time. It was stupid. I'll be honest. I had clients that stiffed me and didn't pay me, and it wasn't because I didn't bill them. Or didn't tell them they couldn't have any more work. Functionally, the biggest issue that I actually had was that I hate.
Oh, thank you, Vaughn. You guys still heard me, though. You could laugh, so we're good. But beyond that, beyond the fact that, it tanked and I didn't make any money and had to go back into practicing for somebody else, the first time anyway, my biggest issue was, when I was talking about choice of entity, and when I start thinking about it, there are kind of two things that come up for me. The first one is how am I going to set myself up? And I will tell you that taxes are my biggest issue, because when I was a PC, I had to do my self-employment taxes, I had to file 940s and 941s, and let me just tell you, I stink at all that. That's what I know.
I always just get a tax attorney or a CPA.
No, I have a fantastic JD CPA who handles everything for me now, except for he keeps telling me he won't be my bookkeeper. So the last time was a PLLC. It was straight pass through and called it a day. He's like, yeah, I'll figure it out on your tax return. I'm like, fantastic. But the other issue that I see more and more, and I see it for me in my practice now, I think about it for solos, I think about it in any practice size, and that is knowing who your client is. And we provided materials that are on your flash drives, and when you look in there, you're going to find some information about specially designated nationals and political persons and doing an Office of Foreign Asset Control check. I highly recommend that you know a little something about your clients when you take them on, because they could walk in from anywhere. They could be doing anything depending on what your practice is. There are restrictions in certain parts of the country, for example, real estate deals. Manhattan, the 5 boroughs are a big one. Miami, Hawaii, California now has 5 counties involved. So those are the types of things that, we may know how to do what we do really well. Vaughn does M&A, and Matt does tax, and John's a corporate lawyer, and I'm in-house, and we do what we do, and you guys do what you do really well. But it's all those other things that we don't have time to keep up with because we're so good at what we do. And then actually, to Vaughn's point, managing the business, that's a tough one, to be a small business owner and a lawyer.
Thank you, Lori. And John, you had a career in big law for quite some time, and now you are one of 2 partners at a boutique law firm. Can you give us a perspective on what may have blindsided you or taken you by surprise in that process?
Well, there was the OMG moment when we decided to do it and realizing it was down to you. That was kind of scary, but pretty quickly my partner and I decided we actually really liked not having a boss.
That is the upside. Because you make those cost-benefit analysis about when you take off work and when you have family time.
Exactly. There is, and you know, you're not reporting to a committee. They're not looking at how many hours you recorded this month. It's all down to you. And that's actually nice.
And nobody's assigning you points. I understand big law firms sometimes get point systems, and I've got so many. I had a points review today. I hear people say, and I'm like, yeah, I've never had a points review because I've always been a solo. And
I can't upset so-and-so or so-and-so because when it comes to negotiation time, you know, I'm going to get dinged. You know, it's all down to you. And when those big bills come in, that's sweet.
Yes. And Matt, did you have anything that took you by surprise when you went out on your own?
But I just want to say how correct John is, how great it is not having a boss. So that's one thing. But New York is really dominated by large firms. The New York City Bar Association is the only bar association that has an organization within it solely for small law firms. Because in most cities, it's basically all smaller law firms and a couple larger ones. And one thing that really, I don't know if surprise is the right word, but amazed me is this very, very small law firm, 3, 4, 5 people and solos who really have a lot of technical expertise in sometimes a variety of areas, but sometimes very specific, very, very narrow areas that exists. And you sort of have to do networking to find people and understand what exists and understand sort of where you fit into it, but just the breadth and wealth of experience and expertise that exists at places that aren't, 500-person firms that are in Midtown or downtown. And that's one thing that really, I guess, surprised me. I felt like it existed, but that's where I would go with it. But not having a boss is really awesome too, how much fun it is.
And thank you, Matt, for pointing out the support that the City Bar has. There's a number of things that you can do as even a solo. Myself, for instance, I'm on the small law firm committee here at the City Bar. And most of the members of that committee are solo practitioners or from very, very small firms. Although the City Bar's definition, I believe, is 24 lawyers or under, most of us on that committee are not from firms that large. There's also mentoring circles that the Small Law Firm Center has. Also, if you don't have premises, because this is a very expensive city to have an office in, I have an actual office in Syracuse. I use the City Bar's virtual law firm service, so I have the address. They have used the backdoor address on 43rd Street. But there are also meeting rooms that you can use and up to 2 times per month for free, and then I believe you're only paying $75 for a 2-hour slot to use those meeting rooms here. And I can tell you it's a real wow factor for your clients when they arrive at, a columned marble building in Midtown. And like, wow, this is where you meet people? Yeah, this is where I meet people because I'm so important. But that's just a few of the things that the City Bar can do for you. So like I said, and nobody's asked me to say this, and I'm not being paid to say this, and I don't work for the City Bar, but consider joining the City Bar if you're not already a member, because the City Bar, like Matt said, more than any other of the bar associations I'm involved in, has a lot of support for small firms. And I think we are out of time.
5 minutes.
Oh, we have 5 minutes? Okay, all right, so why don't we do questions then? That's perfect. Yes? Okay, for the rest of the room, if you couldn't hear him, he's asking the question, why should a solo register as a PLLC? For instance, Lori, what?
I'm sorry, is that as opposed to like just being a sole practitioner unincorporated? Okay.
Do you have any thoughts, Lori?
My biggest issue when it comes to that choice or that question is really, what are my tax consequences? What's my financial picture? What can my CPA do for me that he couldn't do for me on a sole proprietorship? Do I have any issues with where I have employees? Would it be more beneficial to have a different tax application for that reason? That's really, finances are my biggest motivator, I will be honest, and say, because when you get down to the liability, quite frankly, we're all going to end up carrying malpractice insurance if we're on our own, and an entity isn't really going to protect us at that point because we're still going to have it. So to me, it's a financial decision, and that's the reason that I make the decision which way I'm going, is what kind of tax consequences do I need? And that's a very personal decision with your CPA. I recommend every client, for every reason, doesn't matter what type, go sit down and talk to your CPA about your financial situation and what's best for you.
And I'm going to add just a little bit. I'm going to take a slightly different tact in that I do think it's important, the choice of entity, but I also think you have to weigh it against the fact that if you're just starting out, you're probably not making that much money, or not immediately. And as a result, you know, what you're talking about is maybe, you know, I mean, you're talking about, I think, you know, the delta is maybe not so big. I mean, sure, it's going to be bigger 10 years down the line, 20 years down the line, but I also think that it's more important to get clients than it is to be perfectly right on your first entity. I think it's more important to get clients in the door than that. And Lori's going to probably fight with me. Go
No,
ahead.
actually, I think that's
I was going to say, sometimes people say perfection is the enemy of progress. If you want to be perfect, sometimes you never take that first step. And we all know to be able to be successful in any measure, you're going to have to start just taking that first step and one foot in front of the other. So let's move on to the next question. I see a hand right here.
Yeah, there was mention of the fee dispute arbitration. And has anybody actually gone through it, or to what extent, what's been your experience versus trying to settle before that?
I don't think anyone in the panel has gone through this, but I will say one thing as far as fees and retainers are concerned. If your clients start to ask questions and sound nervous about where their money is and what they're paying for, schedule some time to call them on the phone and have a very long conversation with them. Whenever I start to have a client who seems to not understand when I'm getting paid, and it's usually because they're afraid they're paying me more than they are. Because everybody's fear when they talk to a lawyer is they have to hold onto their wallet really tight. We have a reputation for being expensive and whatnot. So if you start to feel like a client, because as John said, your retainer agreement and or your letter of engagement is the start of your relationship with your client, and that's a trust issue. So when you're seeing that trust issue with your client, you need to start having a conversation with them. Say, here's where your money is. It's sitting in my retainer account, my IOLA account. Until you get a bill from me, it's going to stay there. And this is also something you should cover in your retainer agreement as well. I think that's one thing that we didn't talk about. In New York, and I believe we're the only state. Do you want to talk about this one?
No, I've had experience.
Oh, you have? Okay, I'm sorry. In New York, it is permissible to put retainer funds into your operating account. I do not do that. But if you're not going to do that, best practice is to put language in your retainer agreements and in your letters of engagement saying, I will keep your retainer in my IOLA account, and as I issue bills, I will be moving it from the IOLA to the operating account. Just because some people interpret that rule that it's permissible, that's the way it should be done. So, Vaughn.
I have sued somebody, and I would say do it smartly. So the moment that I sued that person, they had a bank that they had to give notification of suit to, and they were trying to get money from a bank. So the moment I sued them is the moment I got the check. So before you sue somebody, right? Have an understanding of what the facts and circumstances are with respect to that client, and to see whether you have leverage or not. If you don't have leverage, I would think that going through, the arbitration would be, kind of time consuming, and you wouldn't get a great result.
And I certainly have let things go when I know that I can't get blood out of a turnip. I just don't do any more work for that person and make sure to get retainers up front as much as I can. And I've just been signaled that we're out of time. So I just want to let everyone know that the next thing on the agenda is the coffee and networking break. And after that, in this room, there's going to be the track 1, create your best networking strategy. And over in the CLE Center, which is this way if you've never been there before, is going to be track 2, legal services, contracting opportunities with government entities in the New York City area. And that's going to be teaching small firms how to get retained by the City of New York for business. So thank you.